space, I think we'll be focusing more on the patent domain right now, primarily because the protection that the patents offer are much larger as compared to the other forms of IPR, and also the strength of patents is much larger. But again, patents are also a complicated field in the software asset protection space. Many of you might have heard that patenting software is really a tough space, and there are really complications around it. And I would say that's true. Softwares are not so straightforward. So before even we go into the other IPS space, let's start off with patents and just focus on what is the patent and what kind of protection does a patent provide. Patents are again the one of the forms of intellectual property rights. They are unique. They are there to protect any kind of innovation, any kind of technical innovation in this field. They are given for a period of 20 years, starting from the date of filing, and they can be taken to multiple countries based on the first filing country of that patent. It is a very important thing to note down that the patent is the journey. That there is a long journey for patent. As soon as you file a patent, your job is not done. It has to go through a lot of processes. It has to be verified by the patent office. There has to be proper prosecutions around it. Then after, if the patent gets granted, then there are phases of maintenance as well. So where you have to maintain the patent for the 20 years. So it's a very expensive process. It's a very streamlined process, and there are a lot of conditions attached to it before you even get a granted patent. Filing of a patent is no doubt a very I think is the first phase only. So when we look into a patent, there are four major criterias which we need to fulfill. First being novelty, that the element of the inventions must be new. They should not be something which has been already patented or already discovered or like already implemented by different people around the globe. So the new is the first and foremost criteria for a patent application. So even if a patent application is new, the changes that has been made in the patent application, or the innovation that has been made, might be very obvious for a person still in the art. When I say a person skilled in that, it means any technical person who is working in that field. So the second condition is that it should not be obvious. Now, historically speaking, this kind of a criteria for obviousness, which was not there when the patent system started in the 1800s, but it has been slowly put in practice in all the laws, primarily to stop getting patent protection on just incremental innovations. So there has to be a substantial difference between what was already there and what we are claiming to have patented or invented. Third is for the industrial applicability, or it should be a useful thing. It should not be something which has got no utility. So mostly there are very few. I haven't seen any case where the patent office has objected on the industrial applicability. The fourth being patentable subject matter. This is one area in which the chances of a software application getting attached to. So we will be dealing in depth of this patentable subject matter a lot going ahead in this presentation. Now, why is there so much of ado about these software patents? If we remove the word software from patent, they should follow all the four above conditions that has been mentioned in this previous slide for getting a grant. I think that's true for all kind of applications. If the software patent application is novel, it is not obvious, it has got industrial applicability, and it includes patentable subject matter, then it should be getting a grant. And this is true across the globe. There is no country where this thing is not true. However, there are a few terms which precisely creates the problem for software applications. Now, the term is in most of the laws around the globe with software programs or like computer programs. The term that has been regularly used is per se or as such. Now, now the word per se or as such means that this is the area in which the entire dispute has been going on for the last 5, 8 years. In fact, more than that. So there has been a lot of guidelines, a lot of case laws on which different patent offices have spoken a lot, and they have tried to put in a consistency-based approach where there's a bright line into it. So for example, in the Indian context, Section 3K is is the section which particularly deals with computer programs per se, and there are a lot of cases in which in India there's historically software patents have been rejected for a lot of conditions, but the patent office in India have taken keen interest on this, and they have made a separate category for such kind of inventions which are into the computer-related inventions. There has been 3 or 4 guidelines into it. The High Court, the High Court have also taken special notice of these kinds of patents, and they have laid down a lot of methods, a lot of guidelines to assist inventors in this process of creating a bright line for the patent domain. Now, inventors have faced similar challenges across the globe on software cases. So let us now take the case of a mobile application, and then understand how do we go about protecting the software things via different forms of IPR. Let us consider that the app has got a lot of widgets, and there are a lot of different functionalities assigned to the app. Now, on the question of can I file a patent in a mobile application domain, the short answer is definitely yes. You can always file a patent application. There's no one stopping you from filing a patent application, provided that there are a lot of aspects on which you have a serious interest of getting it granted. Then all the conditions that have been mentioned before, those conditions are being fulfilled. Now, a lot of instances, it has been seen that patent applications have been filed without conducting a proper due diligence of what should be the patentable subject matter here, or where are our focus areas, in the invention. Please avoid filing a patent application, particularly in software, without conducting a proper assessment of where your invention lies. Just capturing or filing a patent which is a picture claim of your mobile application or software will not give you a patent. You have to show under the law that there is a technical advancement as compared to the existing technology, and or you are trying to solve a technical problem which has not been done before. There are a lot of examples of mobile applications which have been granted. I will be discussing showing an example of like how it is done. But very important here that you conduct a due diligence and understand from point of market or from the point of jurisdiction in which country your product will be maybe launched in the next coming years, that how the patent should be taken forward. It is not a straightforward thing just to blindly go ahead and file a case. Now, what are the different IP protections that you can provide to a mobile application? Patents, we have been discussing the patents for the last few minutes. Again, there are trademarks on the name, on the unique taglines that you might have. So definitely go for the trademark applications. Copyright, I think the code should definitely be copyrighted, even though there is an inherent registration of the mark as soon as they are created. But it is always better to have it registered with the Copyright Office, because it gives you a bona fide proof that the code was being protected at that time when we were working on it. Another thing which is most important and which most of the software cases nowadays don't follow is for design protections. Now it is understood that in India, design patents on the user interface of the app is not allowed. but there are other jurisdictions, for example, in US, in Europe, or in Singapore, or in Australia, there are multiple countries on which there are design patents are being given to the graphical user interface. Now, now from the Indian perspective, if you want to protect your graphical user interface, then you can copyright that at interface, but you cannot file a design and patent on that, because there's a certain clause in the law in which it says that it needs to be an article of manufacture. Now, graphical user interfaces are not article of manufacture, so thus this problem. I hope there are some policy changes in future where through which design patents on graphical user interfaces are also allowed. Now, let us take this case of an Indian granted matter in which was particularly related to creating a user interface view for the user. Now, this has been recently granted by the Indian Patent Office, on which there were three layers in the for presenting content to the user, and this is a smartphone based application. Here, there were three layers, as you can see L1, L2, and L3, and these layers together were producing an effect on the user interface. Now, this application had a technical problem. The technical problem was related to the how the content, how the images just would be changing their colors when there is, say, when there's bright sunlight on the screen, or it's in the dark mode, or how it is to be presented. So this invention was basically able to capture all the near about data around the smartphone, and then give the user a very customized view of the content from the mobile phone. Again, we also had a design protection on this, on the interface, and again we had also got a granted patent on this case. So when you are going for right now, as per the application or the strategy, what are the key aspects which you should consider before you go for patenting or protecting your software assets? First of all, you should go for trademarking the application. In fact, the name of the application. Then the copyright right of the code. Third most important thing is look into the market that you will be probably selling your software codes, be it in the form of SaaS or PaaS, or like any other firm. If they are into, if your probable market will be in US or in Europe, please go ahead and protect your protect a user interface. And then depending upon your market, please try to use your invention to break it into features or aspects of the claim, and then check whether they fulfill the guidelines of the patent offices in which jurisdiction they are supposed to be filed. So for example, if you are going to file a patent application in US, do conduct a check on the Alice guidelines whether your software application fulfills the requirement under the Alice guidelines. If you are going to UK, then definitely on the HTC on the HTC and the Apple guidelines there. If you are going to Europe, similarly, if for guidelines, if you are filing in India, then definitely the IPO guidelines or CRI guidelines. And with respect to the software patents, they must be ascertained prior to drafting and filing the applications. Once you have ascertained all the guidelines, conducted a detailed check of where where the problem lies, then you should go ahead and then draft the claims. Now while drafting the claims, it is also very important to connect it to the hardware elements, to show that there's a practical application of the mobile application, and then they are just not being made as a statement, and there are technical means, or there are different kind of algorithms through which you are able to implement that software. It should not just be an idea of itself. It should definitely be precise in giving a detailed description of how it works, how the coding works, and how it interfaces with the hardware. As much detail as you could give in this application, the better are your chances for overcoming software related objection. And obviously, if there are technical technical advancements that you have already figured out in your analysis stage, then you should definitely clearly mention those technical problems in the specification as well as in the background, and then mention the technical advancement which you consider is happening over the prior art.